My mother said, be independent, and by that she meant I should be able to make my own way in the world, even if I met Prince Charming. Although she died when I was 17, she influenced my approach to life. I graduated from law school in 1959. There were no anti-discrimination laws, and employers were upfront that they did not want a woman. And even if they would risk taking a chance on a woman, they surely would not take a chance on a mother with a 4-year-old child. My object and the object of the women in my class was to get a job, and that was no mean feat. Judges understood by that time that racial discrimination was odious, but they thought that laws discriminating against women were for the women's own protection. So my job was to let the court see that these classifications more often put women not on a pedestal, but in a cage. A man on the train was reading the New York Post. He held it up, and I could see the banner headline, Supreme Court Outlaws Sex Discrimination. I was exhilarated, and it was a great beginning.
Welcome back to the Millennial-Review, the podcast where we analyze the current political, cultural, and socioeconomic crises we face from the perspective of the most indebted and disenfranchised generation in history. I'm your host, Justin, here with a not good solo episode, not great circumstances. As all of you, I am sure, undoubtedly know, and if you didn't know, the title was probably a rude news update, but as it states, Ruth Bader Ginsburg has passed away. She died of pancreatic cancer at her home in Washington, D.C. at the age of 87. I honestly don't even know where to begin. There is just so much that can be said. There's so much that needs to be said about her life and her legacy, both the good and the bad. I will at some point make a podcast highlighting why I think the cult of personality that developed around her was so problematic. But that said, she was genuinely influential is understating it. She genuinely changed the trajectory of the law. And again, go listen to my All Judges Are Bad podcast to get a sense for how I think that actually happens. But Ruth Bader Ginsburg was the lawyer representing that movement in the courts, the movement, the feminist movement, the movement for women's equality. And that is a movement that she pushed forward tangibly and brought the Supreme Court to recognize gender discrimination as something the Constitution protects against, the 14th Amendment protects against, the same way it does racial discrimination. I mean, Ruth Bader Ginsburg championed those arguments, brought them before the Supreme Court, and makes sure that our constitutional doctrine protects people based on their gender identity. And while maybe she didn't lead this fight directly, when you go look at an episode I made like over a year ago on how our legal system and legal doctrines sort of systematically and structurally ignore non-binary and trans people, this legal fight to bring legal recognition to those people and their identities is just impossible if Ruth Bader Ginsburg isn't there sort of representing the second wave of American feminism in the courts in the way that she did. And her legacy goes far beyond just the work she did to further gender equality, which, working as a professor, a Supreme Court advocate, and then later a judge, that work was huge. And while I don't think individual jurists or lawyers or judges should be the ones shouldering the credit for movements, we do need talented people in the halls of places like the Supreme Court, and Ruth Bader Ginsburg was that talented ally to the extent that almost anyone else is. And again, there's problematic aspects of her record. Go listen to my patron-only episode on McGirt v. Oklahoma and some of the tensions there. And there's a lot, but this I don't think is the time to really unpack all of that, because there's more immediate questions, I think, both politically, legally, that this has huge implications for. And while, we'll take down the cult of personality around Ruth Bader Ginsburg someday, because that's important, I think today it's important to really contextualize her legacy and appreciate that while I genuinely do think judges are structurally limited in the good they can do in the American system, as far as a good versus a bad judge, she was on the right side of that spectrum. And not only that, it looks like there is high likelihood that she will be replaced with someone who is particularly bad. And I mean, that's another dynamic we'll get into. There's, like I said, I don't know exactly where to start, because I think there's just so much to unpack here. But at the same time, I think first and foremost, the obvious place is at Ruth Bader Ginsburg herself and her career and everything it represented. And again, there's a lot there, both just as a figure and as a legal professional, a judge, thinker, and legal theorist. And so we'll unpack what this means for the law and all of that. But I think I also just want to state how massive this is and how big of a blow it is for so many people in the legal profession. I think, I don't know, it's hard to explain how patriarchal the legal profession is, that law schools are, that our legal institutions are. And there's just so many experiences of people that I went to school with being told that they can't argue in court in the South because they don't have a skirt on. I mean, things like that I will never have to deal with. But obviously more than that, I think just the sheer pressure and force that comes with being someone who is navigating an institution that's hostile to you. And I've experienced that a little bit, I guess, because I think law is also like old money and rich, wealthy in a way that as someone from a very working class background, I don't think I'll ever relate with. And obviously wrapping that up into our good leftist intersectional analysis that just compounds all of the things, all of the dynamics that I didn't experience that others have, that I was describing. And I think in a really significant way, Ruth Bader Ginsburg, to a lot of people, not everybody, especially given some of her notable shortcomings, but to a lot of people, Ruth Bader Ginsburg represented she was a trailblazer in the truest sense of the word, and represented someone who, if not for her work, like quite literally millions of lawyers wouldn't be where they are today. And that might seem like a small thing, especially given the scope of some of the stuff I talk about. But when I talk about abolishing the Supreme Court or revolutionizing our legal system, I mean, a big part of that is creating legal training and law schools that are hospitable to everybody, creating law firms that are hospitable to everybody. If we're ever going to, in the words of Lenin, quoted from the People's Republic of Walmart, which we're reading for book club and y'all should all join, if we're ever going to lob off the capitalistic mutations that warp and distort our institutions, part of that is reshaping these institutions, how they function. And a big part of that is, breaking down the barriers that prevent people like RBG, women, people of color, people who are gender nonconforming. Breaking down the barriers that prevent these people from changing the institutions from within, from siphoning off the functions and sections of the institutions that are useful and helpful, and reforming them on some fundamental level. I am someone who thinks that as part of that bigger structural calculus, those sorts of things really matter. And Ruth Bader Ginsburg both as a individual who stepped into that trailblazing role, but then used her power to structurally change the system to help make that trailblazing more meaningful. I mean, that is really, really fundamentally important in a way that I don't want it to get lost in this discussion, how just as a figure, the cult of personality, I think, is problematic and undeserved in a lot of ways. But at the same time, I think it happens for a reason, because law is just an incredibly patriarchal institution, and Ruth Bader Ginsburg is obviously a symbol of that eroding in some ways. It's far, far, far from gone, but we have definitely made progress since the 1950s. And to that point, I don't want her Jewish identity to be lost in all of this, because I think along with the very white, very patriarchal nature of the law, it's also very Protestant in the United States, and there has been efforts historically to continue that and maintain that sort of Protestant supremacy within the legal field. And a part of that has been, or historically, preventing Jewish people from joining state bar associations, or at least attempting to get them to, or attempting to bar them. And for example, when Louis Brandeis was nominated in the early 1900s, there was a huge outcry against President Woodrow Wilson, basically just declaring Brandeis an unacceptable radical. Some of his fellow Supreme Court justices wouldn't even attend his nomination. They wouldn't sit with him, just because he was Jewish. And obviously, I mean, this is someone who is being appointed to the Supreme Court. That sort of prejudice is just significantly worse for other Jewish lawyers, and obviously all the worse for people who don't have the power that comes with being a lawyer. But again, I think when you talk about revolutionizing, reshaping, reforming, transforming, whatever words you want to use, when we talk about fundamentally reshaping our legal institutions in some way, we got to walk and chew gum. We got to think about big things like constitutional amendments to reshape the court either structurally or, something more along the lines of ending Marbury versus Madison and judicial supremacy. I mean, those are some of the reforms that abolishing the Supreme Court entails. And when we start thinking of stuff like that, I mean, we got to walk and chew gum. We got to advocate for that, but we also got to advocate for a legal system that's more representative, for a legal system that allows more voices, that allows people to enter into the legal academy and exit capable of advocating for their community. And I think more importantly, creating institutions that encourage that and foster that, and really reimagine the law as something that could be a force for good. And I think in its best, that's what lawyers are able to do. And during her best years, that's what Ruth Bader Ginsburg did. And both personally, by being someone who was breaking down those walls, being one of the first women to attend Harvard Law School, being one of the first Jewish women to sort of enter these spaces, and literally being the first Jewish woman on the Supreme Court. Again, in this walking and chewing gum, restructuring the judiciary, all of that's important, and I don't want that to get lost just because I also want to take it to the abolish the Supreme Court place. It's a long road to that society, that legal system, and while I would like to think that we can just overthrow our institutions and start anew like that, I mean, obviously these are slower moving processes than that, and in the broad scope of history, if we end up at a result something like what I will advocate for on this podcast well into the future, if we ever reach that point, people like Ruth Bader Ginsburg were very important figures in changing that system in so many ways. And the point that she is just sort of a representative in this one institution of a broader movement, and the power that she garnered, the power to make the legal arguments that the 14th Amendment should apply to gender discrimination and should protect people from gender discrimination like it does people from racial discrimination. And I mean, just the ability to make that legal argument and have sway and actually win the day in the way that she did as a professor for Rutgers Rutgers and then Columbia and then the ACLU. I mean, when she's making those legal arguments, I will always contend that the power she is utilizing is actually coming from a movement of feminists and allies and advocates who are seeding the ground for the people in the institutions like the ACLU and the courts and Columbia Law School to make the arguments necessary to push the ball forward. And that's something that's part of the reason I don't like the cult of personality around figures like RBG, because I think it shrouds that story and puts a lot of it on her shoulders. But again, there is a lot of credit that needs to go to her, because playing that role in those institutions, especially at a time when those institutions are against you, and quite literally the president of Harvard Law went to RBG and said, "Why are you here when a man could have taken your spot?" I mean, when you are navigating institutions that want you gone, navigating a legal argument or a legal market, job market post-graduation that tells, Ruth Bader Ginsburg, one of the most talented legal minds ever, that we're not going to hire you because you're a woman, because you're Jewish. I mean, it was incredibly difficult for Ruth Bader Ginsburg to play that role. And again, I don't want to lose sight of that, because there's a lot to be said. There's a lot of criticism to be thrown at RBG in particular, and the courts as an institution. And we're going to do some of that here. We've done some of that here. We'll do a lot more of it in other podcasts. But I just really, again, wanted to highlight the point that Ruth Bader Ginsburg really was a visionary figure and a trailblazing figure and an incredibly important figure, despite all of the criticisms and complaints that I have with her legacy, and really, more importantly, the popular perception of her legacy. And so I think, just to sort of cap that story and the importance of it, I want to give a more detailed telling of Ruth Bader Ginsburg's life. Not very detailed. This is not like a Deb series by any means. I'm really just sort of laying out the timeline so everyone can appreciate where the trajectory of Ruth Bader Ginsburg's career, where she sits in the world of law, where she sits in the world of the women's movements that she represented in the courts, and then sort of the trajectory of her career once she becomes a judge, and where that leaves us, because obviously that's all really important. Her legacy is incredibly important, but also the lasting consequences of her death and the shakeup at the Supreme Court is, I would argue, probably equally important, if not more. And to say that it's equally important as Ruth Bader Ginsburg's legacy is not to diminish her legacy, but to make the point that her dying in this moment in 2020, 50 days away from the election, in this moment in particular, where judicial philosophy is as right-wing as it is, where she is sort of the beacon of liberal legal hope and liberal hope in the Supreme Court in general. I mean, there's just so many implications of this that I think go far beyond just losing that singular voice on the Supreme Court. And in a significant way, I think the legal progress that she helped usher in is at risk in some fundamental way. And that's why I think her death could be just as monumental as her life. And again, we're going to dive into her life a little more in depth in a second, because obviously, as I've said, it was monumental in its own right. And to get a sense of that monumental life, we will, I guess, dive into her life itself. And she was born in Brooklyn, in New York City, obviously, in 1933. Her father was a Ukrainian immigrant, her mother the daughter of Austrian immigrants. Both sides of her family were Jewish. Though they were not particularly devout growing up, they did attend the East Midwood Jewish Center, a conservative synagogue where Ruth and her family were active, and though again not known as particularly devout, their Jewish faith played a significant role in their family and in Ruth's life. Ruth had one sister who died when she was 14 months old. By all accounts, her mother was very active in her life and encouraged her to pursue an education. She wanted Ruth to become a high school history teacher. Unfortunately, her mother passed away the day before her high school graduation. RBG then went on to attend Cornell University, where she received a degree in government and was the highest ranked woman in her class. She also met her husband, Martin Ginsburg, who she eventually married. He became an officer in the Army, which pushed the couple to move to Oklahoma, where they lived for a short time, gave birth to their first child, and during that time, RBG worked for the Social Security Administration. And then in the fall of 1956, she enrolled in Harvard Law School, where she was one of only 9 women in a class of 500 men. And again, this is where the asking why are you here anecdote comes from. Reportedly, the dean of Harvard Law School invited all 9 of those women to his house, sat down at dinner with all of them and asked them why they are going to Harvard Law School, why they think they deserve to be there, and why they think that they should take the place of a man. And that's the sort of thing that Ruth Bader Ginsburg has helped to deconstruct in the legal profession in some significant way, though it is still an incredibly sexist and patriarchal profession with rampant sexual harassment problems at big firms and all sorts of other things that we could point to that just highlight that patriarchal nature. But again, it's a slow road to deconstructing those systems in most cases, oftentimes. And along that slow road, Ruth Bader Ginsburg was a very important figure just by being at places like Harvard Law and being one of those 9 women at that dinner being asked, why are you here? Her husband is then offered a job in New York City, where Ruth Bader Ginsburg then transfers to Columbia Law School, making her the first woman to serve on 2 major law reviews, the Harvard Law Review and Columbia Law Review. And then in 1959, she graduated from law school tied for first in her class. Somebody in today's legal market who was on both the Harvard and Columbia Law Reviews and graduated the top of their class at Columbia Law, I would imagine, would basically have any job they want. They could clerk for any judge in the country. They could probably straight out of law school work for basically any firm, basically any government agency. The world is their oyster, so to speak. But that was not the case for Ruth Bader Ginsburg. No, as she puts it, no firm in New York City would hire her. Clerkships were incredibly hard to come by, even though she had strong letters of recommendation from Albert Sachs, a distinguished professor and later dean of Harvard Law School, and other figures like him. She applied to be a Supreme Court clerk for Justice Felix Frankfurter, who rejected her due to her gender. Similarly, she was rejected by other judges. Eventually, Columbia Law professor Gerald Gunther pushed for a U.S. Supreme Court or a U.S. District Court for the Southern District of New York Judge Edmund L. Palmieri to hire Ginsburg as his law clerk, basically saying that we will never send you another Columbia Law student to work for you as a clerk ever again if you don't hire her. And so she was hired and worked as his clerk for 2 years. Clerking on a federal district court for the Southern District of New York is a prestigious position to this day. It's a competitive position to this day, but someone with those credentials, I think, would get the job probably, and they would be very competitive for Supreme Court clerk positions. And the fact that this was such a process for Ruth Bader Ginsburg that she could not find a job at any law firm, and that these judges were so skeptical, even though she had such significant credentials and really, really high level recommendations. I mean, that is how the legal system was. That's how the legal profession was, and she helped to break down those barriers. I mean, similarly, the first woman appointed to the Supreme Court, Sandra Day O'Connor, she famously applied for a job at a firm, Gibson, Dunn and Crutcher, which is a big litigation law firm, coming out of Stanford Law in 1952 as the third ranking member of her class. And infamously, Gibson Dunn offered her a position as a legal secretary. I mean, this is the kind of shit that really influential and like incredibly talented legal minds on both sides of the aisle, frankly, had to deal with, because they were women coming up in an incredibly patriarchal legal profession. And again, not to overstate the importance, because it's a movement thing, I think, but these people being in this position is important. And I think as we make the legal profession more equitable, to the extent that that's even possible, it comes in the form of making it more accepting for people who the system has not traditionally represented. And we've made progress, but I think we have a long way to go if we're going to create that more ideal system. And again, don't want to oversell it, but the individual contributions of people like Ruth Bader Ginsburg are huge to that end. And the fact that she had such a difficult time getting a job, I think, is really emblematic of some of the changes that she helps create. And in a both a tangible, like, legal sense, she created some of the doctrines that will combat that sort of discrimination in the future. But also, she was a person who was just there, being that trailblazing figure, being the woman being denied despite her incredible credentials and all of that. And that's also obviously incredibly important. After serving as a clerk for 2 years, Ginsburg traveled to Sweden, where she studied the law international at the Columbia Law School Project on International Procedure. She co-authored a book on civil procedure in Sweden while there. Real nerd shit. But I think this is also a time that is hugely pivotal for the work she will do going forward on gender equality. Sweden was a little ahead of the United States there, as one could imagine. And Ruth Bader Ginsburg was researching and working in a legal environment where 25% of the law students and the judges who she was interacting with were women, as compared to a Supreme Court in the United States and many circuit courts that had never seen a woman on the court, and a Harvard Law class that had 9 women out of 500 people. I mean, this was a system that was designed to keep women out of it, and that has obviously huge consequences. And so from that international position, Ruth Bader Ginsburg took a job at Rutgers Law School, which made her only one of 20 women law professors in the country. Again, continuing on her work from Sweden, she mainly taught civil procedure until 1970, when she co-founded the Women's Rights Law Reporter, the first law journal in the U.S. Exclusively focused on women's rights and women's issues. And I think when you just look at the proliferation of women's law journals and women's law reviews and gender critical law reviews, and just the proliferation of really advocacy-based sort of law review type initiatives, those really inject a lot of important ideas and legal arguments into the legal profession. That's huge. And co-founding the first women's law journal in 1970 that is a significant step that opened the door for all sorts of interesting legal scholarship in all sorts of realms, even outside of the sort of discrete feminist project that law reporter represented. But then shortly after that, she received her job at Columbia Law School. In doing so, she became the first woman to ever receive tenure at Columbia Law School, and also became the first person to co-author a case book on sex discrimination. And so this is sort of a time where her advocacy in the gender rights realm really takes off. And in particular, as she's starting to teach at Columbia, she also co-founded the Women's Rights Project at the ACLU and became the project's general counsel shortly thereafter. And this is really the spate of cases that I think will fundamentally transform American jurisprudence and will take the 14th Amendment out of just the realm. I mean, it's already out of just the realm of racial equality. This is sort of the series of cases that will explicitly apply the 14th Amendment, or that will result in the 14th Amendment explicitly being applied to gender equality. And again, go back to my episode over a year ago discussing what sort of changes we would need to see in the legal system to have legal regimes that accommodate trans and non-binary people. All of that groundwork, intentionally or not, was laid by the work Ruth Bader Ginsburg and the Women's Rights Project at the ACLU did in that 5-year span. And again, don't want to put all of that credit on their shoulders, because they are just the manifestation of a movement in the legal system. But that's important. We need to support that. But again, don't disconnect that from the broader social work that is being done to enable that legal work in the first place. As one major legal representative of that feminist movement between 1971 and 1976, Ruth Bader Ginsburg will levy a systematic attack against the legal conception of gender in the United States that will eventually result in an application of the 14th Amendment that looks very similar to how the 14th Amendment strikes down racial discrimination. It's not quite as severe. It doesn't go quite as far. I'm not going to dive into the complexities of constitutional law doctrine right now, but it basically ends in a legal doctrine known as intermediate scrutiny that allows gender-based discrimination to be challenged on constitutional grounds. And I'm going to get into the sweep of those cases more specifically right now. It ends in a legal tool that fundamentally, I think, reshapes our legal system in an important way that is at risk now that she has passed away, unfortunately. Potentially. We'll see how it all plays out. I think I am a pessimist in this situation, but we'll talk about the politics of all of this later, because I want to, again, highlight the really, really important legal work she did as a Supreme Court advocate, again, as the representative of decades of movement building, decades of integrating the women's movement with the anti-war movement, and integrating the women's movement with the struggle for racial justice, and combining all of these movements and really changing political and social consciousness in the United States, really shifting how the United States views women, how the United States views gender equality, and all of that really important work was done by millions and millions of people, and it put Ruth Bader Ginsburg in the position to use her talents and her abilities to make the legal arguments that fundamentally transformed our legal system, and in some ways translated the demands of that movement into a language our legal system understood and could enshrine in important ways. And even though those doctrines are enshrined in important ways, that doesn't mean that they can't be undone. And I think that's where we're headed potentially. But this spate of cases begins in 1971, where Ruth Bader Ginsburg writes a brief for a case out of Idaho, because of course, called Reed versus Reed, which basically stated that the administration of estates, once someone had passed away, that could not be determined in a way that discriminates based on sex. The situation in question was a divorced couple who had a son. Their son passed away, and they were fighting over where their son's assets and his belongings would go. The Idaho statute said that in this situation, males must be preferred to females in appointing the administrator of the estates. So Sally Reed was unable to administer her son's estate. Ruth Bader Ginsburg writes a brief, among other people, basically claiming that this should be against the Equal Protections Clause, that the law shouldn't be able to classify gender in this way and use gender as the turning point in the law. Like, all things being equal, these two people have equal say to their son's estate, and the only thing making that decision is the fact that his mother happens to be a woman. And that is obviously absurd, and that is what is being highlighted by people like Ruth Bader Ginsburg. And for the first time, the Supreme Court applies the Equal Protection Clause towards women against legislation like this in this way. Chief Justice Berger writes in that opinion, to give a mandatory preference to members of either sex over members of the other merely to accomplish the elimination of hearings on the merits is to make the very kind of arbitrary legislative choice forbidden by the Equal Protections Clause of the 14th Amendment. And whatever may be said as to the positive values of avoiding intra-family controversy, the choice in this context may not lawfully be mandated solely on the basis of sex. And so he unpacked the counter argument there was basically like, yeah, whatever, it's sexist, but we're doing it for administrative purposes because it's just easier this way if it just goes to the men in the family. And for the first time, the law said, no, you cannot make gender or sex in this case, but Ruth Bader Ginsburg will turn the argument to gender, which I think is important, even if they didn't do it for the reasons it's important today necessarily. For the first time, the court is applying the Equal Protections Clause of the 14th Amendment to protect women. Ruth Bader Ginsburg engaged in all sorts of advocacy in lower courts, but on the Supreme Court level, she filed an amicus brief in the case Frontiero v. Richardson, which it was a case basically discussing the challenges that women in the armed services faced getting increased housing allowances for their husbands, as opposed to the process for husbands to get that same increased housing allowance for their wives. Ginsburg argued that the statute treated women as inferior, and it made no sense, similar to the Reed versus Reed, the only distinction being gender there. And the Supreme Court ruled in Frontiero's favor, using the Equal Protections Clause to protect women once again, 8-1. And the tide had really turned. In just a few years' time, this argument appears for the first time, and it's starting to fundamentally change policy at the Supreme Court level, in the sort of lower level court advocacy people like RBG is engaged in, but even like state legislatures are seeing that this is going to have huge implications, and we have to basically rid the law of any gender distinction that is like functionally significant in the way that the Reed versus Reed distinction was. And in a significant way, RBG was on the front lines of fighting that fight. And again, she is standing on the shoulders of giants, which I think in a lot of cases, the giants are construed as the figures like RBG, and in some sense she is a giant, obviously, but she herself was standing on the mountain that a movement had created and given her the platform to yell from atop, and that translated to tangible legal outcomes and results that fundamentally transformed American society in a significant way. This time, she was also bringing cases that argued the flip side. So in a case called like Weinberger versus Weisenfeld, Ginsburg argued there was a widower who was denied Social Security benefits that widows could collect. There were special benefits allowed for widows that widowers couldn't collect, and while caring for minor children. And she basically argued that discriminated against men, and men needed that money to take care of their children and families as well, so it just didn't make any sense for that distinction to rest on gender alone, and that was struck down as well. And just repeatedly, this legal argument that she helped craft, it becomes fundamental to changing these legal doctrines. And to this day, again, go back to my episode on trans and non-binary inclusive legal doctrines, because that is the exact same doctrine that will be used to fight that fight. And it fundamentally changes American society in the 1970s, reaching, I think, its peak. Most constitutional scholars would agree with the case Craig v. Boren, which sets the intermediate scrutiny standard on laws discriminating based on gender. It's a heightened standard of constitutional review. This is oversimplifying it a bit, and I'm not going to get too in the weeds here, but there's rational basis review, intermediate scrutiny, and strict scrutiny, which is used in the case of racial discrimination. And essentially, the government needs to provide increasingly valid justifications for their discrimination based on, so in the case of racial discrimination, the government will look at a law and say this is using race as the turning point in some functional way or a policy, and strike it down on that grounds. And you have to have a compelling government interest to avoid that, basically. And the only place that's really gained traction outside of, you maybe could argue, a like narrow affirmative action argument, but I'll unpack that because this has been used to strike down affirmative action by and large. The only place that argument has really effectively been countered, though, is cases like Korematsu, which was the Japanese internment case, or some things coming post 9/11, where there was laws that seemed pretty discriminatory, maybe not on their face, but basically pretty close, and national security was wheeled out as the compelling governmental interest. But it becomes very difficult to legislate on the basis of race once the 14th Amendment is used to create this heightened scrutiny and strike down race-based legislation. Similarly, there was a push for heightened scrutiny for the same strict scrutiny standard to be applied in gender discrimination, but the court decided that there are some contexts where that actually makes sense, so it's intermediate scrutiny. You don't need as compelling an interest, basically. Again, I'm oversimplifying this, but you still need something that's pretty compelling as compared to like rational basis review, which is like the justification for a speed limit regulation. It just needs to like make sense, basically. It's really, really hard to overstate how important Ruth Bader Ginsburg's legal advocacy was in the 1970s towards translating the women's movements and their allies and the movements that they built together, translating that into meaningful legal reform and change. And I think it wasn't even, I think you could argue that it went beyond reform, that in some ways those legal arguments and the movement that undergirded them fundamentally transformed American society for the better. And that is, Ruth Bader Ginsburg does not deserve all the credit. Many people in the United States, especially liberals, love to give Ruth Bader Ginsburg all of the credit for that movement and the legal articulation of that movement, but she does deserve a significant amount of credit. The same way that the legal progress represented by the civil rights movement cannot rest solely on the shoulders of Thurgood Marshall, but you cannot have a discussion about that without Thurgood Marshall. So Ginsburg was hugely, hugely important, and work that she did remains with us today, remains incredibly important today, and is at risk because of her death. And I guess when I look at judges, like I said, all judges are bad, and I will continue to make that case. And I think part of it's because figures like Ruth Bader Ginsburg and Thurgood Marshall, who are in my top 5 favorite Supreme Court justices, are constrained by the judiciary in a way they simply were not when they're acting as legal advocates. And there are a lot of really understandable reasons for that, as you can imagine. I mean, when you're acting as an advocate in a discrete area of the law, you have a better grasp on all of the potential consequences of the arguments you're making, of the changes you're trying to usher into society via the legal system. When you're a judge, you are dealing with every issue that is put before you, from really complicated questions of civil procedure, dealing with cases between multi-million-dollar corporations that have effects that will ripple through entire communities, to looking at the individual habeas corpus petitions of prisoners that drafted them themselves in law libraries at the prison, to fundamental questions of constitutional law. So you can't, I think it tempers you in a way. You have to be more moderate, because you can't have an expert view of the consequences of all of your actions. And I think in the case, that's how I justify the transition from advocacy lawyer Ruth Bader Ginsburg to more moderate DC Circuit Court Judge Ruth Bader Ginsburg, because she's appointed to the federal bench in 1980 to the United States Court of Appeals for the District of Columbia Circuit. DC Circuit, the most important circuit in the United States. And that's because it gets a lot of issues from the administrative agencies in D.C. and just has a lot of sway there. But on this court, she worked with Robert H. Bork, who is a influential and infamous figure in conservative law and legal circles. And Antonin Scalia, who you probably have a better grasp on how influential and infamous he is. Those were some of her colleagues on the D.C. Circuit Court, and she really crafted an image on the court as a cautious jurist and a moderate. She was appointed to the D.C. Circuit Court by Jimmy Carter, and she really was willing to work across the aisle. And again, I think part of that is you're moving to a broader realm of law where maybe your more liberal political sensibilities are more at work. You have this radical view of equality. You have radical views on maybe what an egalitarian economy looks like to a certain extent. Like you have these views that you can operationalize as a lawyer, but once you become a judge, it becomes harder to justify that sort of advocacy. But also, there's just so many issues where your grasp of the consequences isn't as great, and you're just not willing to go there in the same way that you are as an advocate. So there's those structural dynamics at play. And then I think, Ruth Bader Ginsburg is an influential legal thinker at this point. She's fundamentally transformed American society in some ways, or helped to. And she is sitting on the court that feeds into the Supreme Court in a major way. Bork was appointed, but his nomination, he was nominated, but his nomination was struck down in the Senate, and that's why he's infamous in many ways. That's kind of pointed to as like the beginning of the partisan judiciary era, if you want to say that there was ever a beginning to that. Obviously, Scalia was right there with her and ended up on the court. And so there's a sense that you will end up on the Supreme Court potentially if you're on the D.C. Circuit Court. Kavanaugh also was on the D.C. Circuit Court. So it kind of behooves you to play the moderate role potentially. At least that was the thinking of the 1980s, I believe, for the most part. And so there's a lot of reasons for the more moderate posture of RBG on the D.C. Circuit Court, and I think a lot of the same pressures and structural things apply when she gets to the Supreme Court. And so when I'm saying like all judges are bad and not even 9 Sonia Sotomayors would be adequate, I mean that like these institutions from like the way they interact with society from like the law school level on up, like fundamentally like who gets to the point that they can even apply to law school, like all of these things that shape our legal institutions on all of these levels are so fundamentally like rotten to the core that I think 9 Sonia Sotomayors isn't even a useful hypothetical because we'll never get there. But even if we did, the way that the institutions function would create a situation where it functionally didn't matter in the end and sort of reverts back on that process. And I think so you can plug in really great committed advocates who did really great important work, who have really great views, be it RBG, Sonia Sotomayor, whoever, and you are fundamentally going to get a lot of bad outcomes because it's just an institution that I don't think is capable on some level of creating the outcomes that we would like to see out of it a lot of times. And again, go listen to my All Judges Are Bad episode to get a more in-depth discussion of that dynamic. And I think part of the problem is the left doesn't have a comprehensive school of judicial thought that lines up with its political goals the same way the right does in the balancing act between originalism and textualism that the Federalist Society and other conservative jurists have struck in the modern era. I mean, we need to develop that system of legal thought so people like RBG don't have this mixed record where they do really, really well on issues of gender discrimination and gender rights, and they continually drop the ball when it comes to indigenous sovereignty. And so like systematized leftist legal thought, I think, is necessary and something we're severely lacking. So you get really great advocates who have good intentions and good views, but are plugged into a system that doesn't allow that to be systematized, doesn't allow that to materialize in other aspects. And then you get this checkered history of someone like Ginsburg, who was really transformative, really fundamentally revolutionized American legal system and society in important ways, but then rises to a position on the Supreme Court where she does very important work that is continually influential and will continue to be influential, but is more checkered than you might think looking at her record coming out of the 1970s. And not to contribute to the cult of personality by blaming that on the institution, but I think that it's not a coincidence that I will tell you that Ruth Bader Ginsburg is totally inadequate in a lot of ways, and she is not nearly as great as liberals want you to think, but then at the same time, she's in my top 5 favorite Supreme Court justices just because the institution doesn't really allow for people that I would consider my favorite to flourish. And there's a lot of reasons for that. And some of them we just discussed in the context of RBG and her time on the DC Circuit Court, but she was able to play that moderate game that I'm not the radical who overturned the American legal conception of gender in the 1970s, or the American legal use of gender in the 1970s. And she had endeared herself to people like Senator Orrin Hatch of Utah, who helped suggest her nomination along with Attorney General Janet Reno and others. And she was nominated by Bill Clinton in June of 1993, making her the first Jewish woman to sit on the United States Supreme Court and the first Jewish Supreme Court justice since the resignation of Abe Fortas in the 1960s. Unpack her Supreme Court jurisprudence a little bit, but I think I'll continue with sort of the thrust of her advocacy in the gender area and gender and the law, because I think it's sort of where her advocacy is most robust and where the potential for a really like zealous left advocate judge is at its most evident, because there's a lot of there's a lot of things you could point to in Ruth Bader Ginsburg's career to erode the cult of personality that was built around her. And I think it's important to do that. But those bad moments and the limitations I discussed earlier notwithstanding, she's also an example of an advocate attached to a movement who was integral to the movement, who took it seriously, who strategized for it, who thought about these things deeply, and then became a judge. And I think in that one discrete area really materialized those politics into really well thought out legal doctrine that transformed American society. And she continued to build on those transformations in that area and others, but really in that area as a Supreme Court justice. And that's why her shortcomings in other areas are so disappointing. I also think so important to highlight, especially given the popularity she's garnered in recent years, because I think it shows you that, like, A, she's human and that she's not perfect and that she has flaws and that those flaws are important and that they have consequences for millions of lives, but also that those flaws and those bad outcomes happen for a reason. And I personally think the main reason is that she wasn't a leftist, frankly. She wasn't approaching these issues from that systematized sort of frame of view, and to when her politics are at their most liberatory in regards to issues of gender, I think it's because she had that more systematized view of feminism, feminist thought, and the way gender and society interact. And I mean, that's not to really discredit her, because there aren't a lot of judges who have a systematized view like that anyway, that sort of chase those political outcomes. But I would argue that's what the Federalist Society, originalism, textualism, balancing act that I described earlier, I'd argue that's what that does. And so we need to, I think, craft that on the left so we can have figures like RBG who work within a framework that blunts some of those incentives that being a judge and the broad range of work you do as a judge offers you, and it incentivizes you to moderate and to liberalize, when I think if we could create an equal but opposite frame for the left and a left conception of law, you could have figures like RBG who have the liberatory gender politics, but aren't approving pipelines that trample indigenous sovereignty. And so that's why the context is so important, and that's why viewing judges and the courts as institutions and not individuals is so important, because Ginsburg really was great in some areas, and she was really awful in others. And there are reasons for that. And those are things that we need to approach realistically and, figure out how that disconnect happens. And I think I have my thesis. I laid it out, and I'll unpack it in other episodes. But I really want to run with her continued advocacy as a Supreme Court justice, particularly in the area of gender and gender equality, because I think, again, it's an example of what a Supreme Court judge that's less damaging could look like. And again, she has her share of bad precedent, to be sure. But I think just one important extension of her work that she did in the 1970s came just a few years into her term on the Supreme Court, when she was able to author the court's opinion in United States versus Virginia, which struck down the Virginia Military Institute's admissions policy that created a all-male institution. Virginia Military Institute is a state-run, fairly prestigious, from what the case law says and the surrounding literature, military-inspired institution. It did not allow women, and given that it was state-run, Ginsburg felt like not allowing women was unacceptable. It was denying women unique educational opportunities that were allowed for men for no reason other than they were a woman. And building on the doctrine that she helped create in the 1970s, intermediate scrutiny, Ginsburg stated that the government must show an exceedingly persuasive justification to regulate on the classification of gender in that way. And again, it's just sort of like a cherry on top of the decades of advocacy, and it's her opportunity to enshrine that on the Supreme Court level. This case was a pretty easy application of already established law, I think, although Scalia would disagree with me and would argue that this was getting closer to strict scrutiny, similar to what's used in the race-based legislation context. But that aside, this was a pretty rote classification of that. I don't think necessarily a good example of judicial advocacy by any means, but just, a decade later in 2007, RBG did engage in what I think could be called judicial activism, and I don't use that phrase like derisively. I think that's what judges should be doing, frankly, which might be a quirky opinion of mine, but I think that in this moment, that is what Ruth Bader Ginsburg was engaged in, and it led to serious policy reforms, namely the Lilly Ledbetter Fair Pay Act. Specifically, it just makes it easier to file unfair pay lawsuits and to win them, and that's obviously huge. Maybe not overstate the significance of the reform itself, given the power of the Supreme Court, but the fact that in her dissent, Ginsburg directly just says to the court, hey, you need to overturn the majority's opinion and make it so we go with my standard that'll make these cases easier to bring. That's huge. That's not something judges do all of the time or very frequently, and it's something that I think a zealous judge would do more often. And in her best moments, and I don't think it's a coincidence that it's in this context, in her best moments, that's exactly what Ginsburg was willing to do, such as in moments like when she joined the concurrence in Whole Women's Health versus Hellerstadt to protect abortion rights in the face of Texas regulations, and she's willing to say straight up, this isn't fair. This is just trying to circumvent the law. You were trying to ban abortion, just calling it for what it is. And again, in her best moments, Ruth Bader Ginsburg was a zealous advocate that transformed American society, and in her best moments, she was an ally that protected a lot of things that a lot of people listening to this podcast care about. That said, she, for structural and probably a lot of personal reasons that I'm not going to speculate on, had moments that were far from her best, where she enshrined laws that enhanced corporate power, and given her, and particularly, I'm not going to get in the weeds of a lot of those because there's a lot of cases dealing with civil procedure and how to bring class action lawsuits and stuff like that, where she, using her expertise in civil procedure, creates a system that very obviously skews towards corporate interests, and that happens frequently enough that there's an ideological thing going on there, and that's a problem. When Ruth Bader Ginsburg continually places corporate interests over native sovereignty in the beginning of her career, that's a problem, though she was on the right side of that question in McGirt v. Oklahoma. And again, there are those structural reasons, there are those ideological reasons for her shortcomings, but she was still an advocate that was incredibly important. And I think going back to the Ledbetter v. Goodyear case, that is particularly important because it's indicative of the form her advocacy takes in the form of dissents particularly. And I think it's also important because it highlights something of a shift in her career in 2007, in that era, when Sandra Day O'Connor steps down from the court, leaving Ruth Bader Ginsburg as the only woman on the Supreme Court, and then Justice John Paul Stevens steps down, leaving her as like the most elder liberal on the court. And I think her judicial advocacy becomes sharper in the era that follows. And so I don't think it's a coincidence that that's when the Lilly Ledbetter dissent comes in, and you see dissents in other high profile cases like Shelby County v. Holder, where that's the case where the Supreme Court essentially guts the Voting Rights Act and removed federal oversight from a huge portion of the country's elections that had previously had that oversight. And I think you can tie that directly into a lot of the voter suppression efforts we see today. And Ruth Bader Ginsburg ties this into a broader history of disenfranchisement, really decries it for as shocking and degrading to our democracy as it is, and really challenged the justification provided by the majority by John Roberts, who's being heralded as some liberal champion now and will continue to, given the ideological makeup of the court going forward, probably, if Trump can get his person nominated, and we'll get into that in a little bit. But in that they basically argued, the majority, that there is not proof that there is racial discrimination in elections now, so we don't need the federal oversight anymore. And again, there's been a lot of tomfoolery, to use a nice word, going on since then that I think you can tie directly to this decision. And in that moment, Ruth Bader Ginsburg wrote, "Throwing out preclearance when it has worked and is continuing to work," preclearance being the federal oversight, "stop discriminatory changes is like throwing away your umbrella in a rainstorm because you were not getting wet." And she saw that for what it was, a gutting of the Voting Rights Act that will restrict people voting, particularly poor people of color. And again, post-2007, in her dissents particularly, Ruth Bader Ginsburg is a fierce advocate for for causes that many of us would champion. In Burwell v. Hobby Lobby, case many of you are probably familiar with, is the case that held that the Religious Freedom Restoration Act shields certain companies from providing their employees with contraceptives per the Affordable Care Act. Ginsburg, again, saw this as potentially favoring religious objections to the law. And I think when you look at the doctrine of religious freedom and how it's been weaponized since then, how it's going to be continually weaponized in ways that will degrade the work Ginsburg did in other areas, particularly gender discrimination and gender rights and gender equality. When you look at the argument in Burwell v. Hobby Lobby, she stood up against it. Had a strong dissent in Gonzalez v. Carhart, a case where the majority, headed by Justice Anthony Kennedy, upheld the Partial Birth Abortion Ban Act passed by Congress in 2003. It was the first abortion restriction case post Sandra Day O'Connor leaving the court. And again, Ruth Bader Ginsburg stood up for the right to choose an abortion, called the majority's decision alarming, and again fits into this broader trajectory of using dissents for meaningful judicial activism. And I think dissents aren't law, so they're not that important on their face, but they become the legal arguments that win the day in the future and in eras to come. And I think part of what I find so distressing about Ginsburg's death is the way some of the groundwork that's been laid by people like Clarence Thomas and Samuel Alito in the form of really out there dissents in all sorts of areas of the law, how those sorts of legal arguments could become activated in a post-Ginsburg court. And that really, really stresses me out thinking about what all that could entail. And I'll get into that in a little bit, because I think that is truly the major implication of Ruth Bader Ginsburg's death, outside obviously of losing the advocate that she was, the advocate that fundamentally transformed gender rights and the law in the United States, and that remained a strong and zealous advocate in so many contexts while on the court. And again, there are a lot of, for every one of these cases that I'm bringing up as a positive, there is something that I could highlight as a negative, and I think that's the nature of the institution, and there's a lot of discussion to be had for how to change that dynamic, and I will have that discussion in the future. I think now the point that I wanted to drive home is that the legacy of Ginsburg needs to be taken in context, and it needs to be taken in the entire scope of her legacy, because even in issues where she's particularly bad, like tribal and native sovereignty, she had improved over the scope of her career, and she has come around to not be a zealous advocate by any means. People in the McGirt v. Oklahoma case were still holding their breath and wondered whether she would come on the right side of history for that case, but she did ultimately. And so these are complicated things. These are complicated issues. They're wrapped up in the institutions of the judiciary and the law. And overall, while I genuinely believe all judges are bad and we need to fundamentally reform the Supreme Court, and I also believe that to the extent the judges institute positive changes, they are given far too much credit, Ruth Bader Ginsburg deserves as much credit as any judge does, I think. With that, I suppose I could go into all sorts of individual cases, but for the sort of broad trajectory of her career, she began as a hugely influential and instrumental advocate who changed fundamentally American society and American law in important ways that we all appreciate to this day. On the D.C. Circuit Court, I didn't really unpack her legacy there, but she was known as a moderate to the degree that she had and made waves at all, which helped push her to the Supreme Court ultimately, where on issues where she had a previous history of advocacy and others, she was really, really stellar, and she pushed the ball forward and continued that advocacy. In other issues, we could make the case that she is almost as problematic as some of the conservative judges, particularly like if you take certain areas of her career and take them out of the context of her broader career, which is obviously unfair. So I could give you good and bad examples of each ad nauseum, and give you good examples of what I think is one of her more endearing legacies ultimately in her dissents and the way she used them to advocate. All of that is important, and I think I could continue to unpack her legacy case by case, dissent by dissent, and give you the good and the bad in that form. And we'll do that more in depth in a Ruth Bader Ginsburg episode, really highlighting the bad as this episode highlighted the good, I think. But again, I don't think this is the time for that. I wanted to contextualize her legacy, what it means for our movement, because she truly was an ally for it, and what it means for the law more generally, and how we can strategize and think about changing the law and utilizing advocates and allies like Ruth Bader Ginsburg and pressuring them to be better and pressuring the next Ruth Bader Ginsburg to not have the same shortcomings. And so we got to unpack a lot to really answer those questions. And we'll get to that, because I think now I want to turn to the political discussion following her death, obviously. I've seen some tweets saying not to politicize her death, and I'm like, what the fuck does that mean? She's a Supreme Court justice. Her death is inherently political. She was politically appointed to a lifetime appointment on one of the most powerful institutions in American society. Like, of course, there's no not politicizing it. It's politicized from the get-go. So, I mean, that's just a dumb point, but it's wrapped up in this American urge to paint the courts as nonpartisan, and that's something that conservatives are running with in this this political debate that's unfolding, basically trying to argue that this is a nonpartisan institution, that Ruth Bader Ginsburg herself was good friends with Antonin Scalia, which shows that she valued this nonpartisan nature of the institution and that we need to go forward with the process because it's what she would have wanted. And that's being weaponized. So, I mean, it might seem dumb, but that's a real sentiment that's out there right now. Obviously, it's supremely hypocritical of Republicans and Mitch McConnell specifically to be talking about filling this seat in an election year to begin with, given the precedent they used to justify stealing the seat that would have gone to Merrick Garland. But that's no surprise to anyone listening to this podcast. Mitch McConnell, for all of his flaws, is a power player. He makes the moves that the power that he has allows him to make. He does what he can to expand the power of the Republican Party and therefore himself and those around him. And he does so, I mean, in expert fashion in a lot of ways and instances. And I think the way he's maneuvered this, his statement is basically saying that because the Republicans won the Senate back in 2014, that gave them the ability to withhold the hearings and wait till the election because that was the will of the American people. Obviously, they elected the Republicans to the Senate in 2016. That gave them the power to do so. Plus, it never happened in an election year like this before, so we just got to wait. I mean, in a lot of ways, he's kind of making the same argument in saying that, like, elected the Republican majority in 2018, so it's their prerogative to do what they want. And in this case, they want to appoint a Supreme Court justice. And I think one thing about Mitch McConnell that I really appreciate is he just takes the mask off the norms and says, like, this is what's really happening. This is what making moves based on power looks like. And the Democrats just don't do that, despite what Fox News wants you to think. So Democrats will spend the next 4 months yelling hypocrisy, Merrick Garland, whatever, but it doesn't matter because Mitch McConnell can make them vote. He can hold the vote. He will. I think it is in his interest at this point. He seems to be indicating to hold the vote. I'm not sure of the timeline. The flakier elements of the Republican Party seem very dedicated or seem to be trying to push for a post-election timeline. We can have the discussion of the nominees and begin the process within the Judiciary Committee, but the vote shouldn't be held till after the election. That is what Susan Collins' office has announced. At this point, Lisa Murkowski has come out, a senator from Alaska, has come out and said no, she will not vote, and we need 4 no votes from Republicans. So that's one. Take Susan Collins at her word that she won't vote yes until Election Day. We'll say that's 2, but if you take Susan Collins at her word after 2016, then I don't know what to tell you. I wouldn't do that, but we'll be generous in this conversation. And then back in May, Chuck Grassley basically said that we can't have a rule that we apply selectively in the way that Mitch McConnell wants to in this situation. So I would be a no if this were to unfold. But obviously that was in May. Chuck Grassley being in Iowa, I'm not purple, but could be arguably in some election state. I mean, who knows whether that was posturing. I don't think he has doubled down on that or announced anything since then, but presumably there's 3 no's: Murkowski, Collins, and Grassley. So if that holds, you need 1 more vote. Mitt Romney seems to be the obvious choice, but there's Cory Gardner, who's in a close Senate race. There's other Republicans in close Senate races: Martha McSally in Arizona, Steve Daines in Montana. And the argument there, I suppose, is that these people will think that wins them the sort of moderate vote. But Martha McSally, I think she's running in Arizona, which is basically at this point a blue state, and could be argued it's a blue state. And she has already indicated that she will vote for Trump's Supreme Court nominee and that she wants to hold a vote on that. And I think she's in the most blue state of these, well, maybe Cory Gardner, probably Cory Gardner, but she's in one of the more blue states of these potentially blue, purplish state red legislatures or red senators whose vote potentially matters. And that she is siding with Trump, I think, is indicative of the calculus here for all of them, because Lisa Murkowski, Susan Collins, from the beginning of the Trump era, have tried to play this moderate thing, and it's been largely almost entirely bullshit, especially in the case of Susan Collins. These other people haven't tried that at all. They have tied themselves to Trump. Martha McSally has continued to. Joni Ernst in Iowa, despite the close race, has continued to. Cory Gardner's continued to. Steve Daines has continued to. And I think it's because they know their base loves Trump, and that's the whatever, they live and die by Trump at this point. And I think in that situation, a lot of these more marginal people who maybe could be convinced by the election, you could see them pulling a Susan Collins or a Lisa Murkowski, and that's totally on the table. I think especially given Joe Biden's lead and presumed victory, like, you're just placing yourself against a lot of people, and you're going to piss a lot of people off by taking a firm pro-Trump stance in this moment. But I also think that there's political pressure on the other side, and that these people have sort of tied themselves to Trump already, and that Donald Trump isn't going to just let them not vote for the Supreme Court justice, especially when he's tweeting already that we need to replace these people before Election Day, and we'll have a nominee by the end of next week. That is Donald Trump's posture. Any Republican that steps out against him will be attacked relentlessly. And so I think there's a group of Republican senators that feasibly you could see flipping, feasibly you could see becoming that fourth no vote. But I think there's questions as to whether they will make the political calculus that breaking with Trump in this moment is what's actually going to provide a boon for them versus potentially a more energized Trump base that wants to win the election and have legitimacy behind a third Supreme Court justice and a 6-3 conservative court. And so I think when looking at who could provide that fourth no vote, I mean, Mitt Romney seems to be the most logical choice at the moment in my mind, and I'm not really sure of the politics and the political calculations that the other potential senators are making, but I don't have much faith in any of them. And so that kind of leaves us at the word of Chuck Grassley from May and Mitt Romney's undecided, as of now, posture, though there are some rumblings out of his camp that he's not totally opposed to a Donald Trump Supreme Court nominee, which would make sense with his general politics anyway. So Donald Trump seems dead set on having a vote. The Republican Party is split to the extent that they've been split on anything in the Trump era, and maybe this split's more genuine, especially also given you have people like Lindsey Graham who are signaling potentially that they're skeptical, and given the discussion we had of Lindsey Graham and the Woodward stuff, maybe there's something there, but I'm not holding my breath for any of these people. And that's sort of where the politics of the vote stands right now. Donald Trump wants it ASAP. A big chunk of the Republican Party does too, but there might be enough holdouts that you can wait till the election. And then at the election, I mean, I don't know what that looks like. I can't imagine Susan Collins voting no on a Republican nominee in the lame ducks period. I can't imagine these people. They might be politicians, but I genuinely think that they believe in the conservative cause enough that voting yes for a conservative Supreme Court justice is worth it, especially if they don't have to have the sort of baggage that comes with doing it before the election. But, I mean, you don't really avoid that by voting for it if Joe Biden wins. So I don't know what the calculation there looks like. All I know is I am skeptical that these conservative senators will find it in their hearts to save the American institutions over enshrine a 6-3 conservative Supreme Court majority. And I think when you look at the arguments being made by Donald Trump, there's going to be immense pressure to get it done. You had Ted Cruz on Fox News last night talking about his experience litigating Bush v. Gore and the importance of getting a complete Supreme Court by the time the election day rolls around so we can make sure our institutions can handle that sort of pressure and that we have a full Supreme Court that can answer those legal questions and sort through those things. There's just going to continue to be those sorts of arguments made and this immense pressure to confirm somebody. And to that end, I just genuinely don't see, if the Republicans make the calculation that pressure is too much and they have to confirm somebody. I don't see them making the Obama move and going with whatever the Republican version of a Merrick Garland would be. The courts have been one of the biggest areas of victory for the Trump administration, and they have filled the federal judiciary with absolute fucking cranks. And that is everything they've indicated since before Donald Trump won the election, is they just want the farthest right elements of the Federalist Society. That's all they're interested in. That's indicative of a lot of Neil Gorsuch's ideology. Brett Kavanaugh is actually relatively moderate compared to a lot of Trump's fucking nominees. And I mean, they're just straight out of that far right Federalist Society milieu. Recently, he released a list that had all sorts of lawyers, judges from all sorts of corporate law firms mainly. But on that list was a lot of names that will ring bells in conservative legal circles. But Josh Hawley made the list, Ted Cruz, Tom Cotton. And I think that list, for whatever is going to be said about it now in the following news cycles, I view it as mostly a political document that wasn't seriously speculating on the potential for Ruth Bader Ginsburg dying and being replaced in the next 50 days. And so that's how I view it, as a way to like get conservatives thinking of what the most like right-wing judiciary could look like, what the wildest dreams fulfilled would look like. And that's why there were so many people on that list, and names like Josh Hawley and Tom Cotton and Ted Cruz. And maybe there's some world where there is thinking that we got to like get rid of some potential challengers to the Trump dynasty along the line, and that would be Tom Cotton and then Ted Cruz, so we got to put them on the court. And I don't think that they're thinking that way. I think it was a political move. But on that list are names that I think will be seriously discussed, and were seriously discussed when the Kavanaugh hearings were being held, and there was like a lot of speculation as to what Trump's going to do if Kavanaugh doesn't make it through. And atop that list is Federal Court of Appeals judge from the 7th Circuit, Judge Amy Coney Barrett. I don't really know how to describe how far right her judicial philosophy is, other than to say that it takes the sort of corporate philosophy of Neil Gorsuch, that far right conception of contracts, and melds it with an extreme social conservatism that comes from her incredibly wacky religious views that those in our Discord characterized, and I think rightly, given activity of People of Praise, the Catholic adjacent religious group that she is a part of. And I think calling it Catholic adjacent would be problematic to a lot of people, in the sense that I could just call it Catholic. But there is a sense that this contention of Catholics and the People of Praise is as far right as like The Handmaid's Tale and like Mike Pence's Ideal America. And I think in a significant way, that's not unfair. It's not an unfair characterization, and those beliefs crop up in her judicial thinking. In the appointment for her seat on the 7th Circuit, Senator Dianne Feinstein of California was quoted saying, "The dogma lives loudly within you, that's of concern," speaking to her religious views and her inability potentially to separate them from issues like Roe v. Wade. That was obviously run with by the conservative circles that love her to begin with, conservative circles who I think rightfully to some degree claim that you can't really separate out those sorts of issues, and that when you have this like secular legal philosophy, it comes at the expense of their worldview. And I think not in the secular religious dichotomy, but in a lot of ways the left has some lessons to learn from that sort of thinking. Definitely not the outcomes that someone like Amy Coney Barrett would push on the court. There are other names. I think she seems the most likely. Just given Trump's persona, like it's the biggest Trump troll move to take the legacy of a woman who did so much work to move the structures of American society and American law towards a more equitable scheme in regards to gender, and replacing her with a woman who is hell-bent on deconstructing that legacy in so many fundamental ways. I just think that is the Trump move. But there are other names that are worth discussing, like Amol Thapar, who's a Sixth Circuit federal appeals judge who clerked for Neil Gorsuch and is a favorite of Mitch McConnell. I mean, it would be a Gorsuch clone, so to speak. Amy Coney Barrett clerked for Scalia. So again, keeping this very far-right judicial philosophy alive and well. There are other, James Ho, a Fifth Circuit former Clarence Thomas clerk. I mean, all of these people are being picked from the very far side of the judiciary, and I think that becomes more problematic than just, hey, we have this one vote now and it changes the balance of power. And that's problematic as well. But I think it becomes problematic in the sense that you see the dissents that Ruth Bader Ginsburg write become important later. You see them change laws later. You see this play out with other judges in the past, and it will continue to play out with Ginsburg's dissents well into the future. Clarence Thomas, Samuel Alito, Scalia, and others have done that work as well. They have laid the groundwork for a far-right judicial philosophy that does not have majority support on the court now, but very well could in an era where Ruth Bader Ginsburg is replaced. And yeah, you have Stephen Breyer, and yeah, you have Roberts, who's a moderate now, which I think is bullshit. But it's not just one vote. Like, even if Roberts becomes a true moderate and really changes his philosophy in some significant way, this dynamic will give you votes elsewhere that you wouldn't have, because, hey, this isn't something Samuel Alito feels too strongly on, so yeah, I'm going to work with you guys because we have a coalition that we couldn't build before, because there's more areas where I can scratch your back and you can scratch mine. This changes the structural dynamic of the court in a fundamental way that replacing Kennedy with Kavanaugh was a move to the right, but not like this will be if Amy Coney Barrett fills the seat left by RBG. And to that end, I'm not sure whether or not they have the votes. I'm not sure whether or not Mitt Romney will come out and say yes, but I know there will be immense pressure for him to. I know there will be a huge amount of his voters that want him to. I know that all of these senators will be in a spot where there will be pressure on either side. And to that point, I want to say that this is not hopeless. Like, there will be a lot of cynicism, especially from the left, that the Mitch McConnell power play is just going to go off without a hitch. But I think if you truly believe in the power of mass mobilization and people's powered politics, then this is a moment for that people power to flex its energy, for us to build power, for us to get organized, to turn that organization for this discrete issue into a network that has lasting capabilities, because this is going to activate people. I have been talking about the potential for Ruth Bader Ginsburg being replaced by Donald Trump to radicalize liberals for a long time. Did not expect it to happen like this, did not want it to happen like this, but thought it was going to be a result, and I guarantee you it will be if that's what happens. We have a chance to activate people, energize them, get them in the streets, and push for real change. And it's going to look like it could happen. I promise you, there will be enough pressure to change the vote of someone like Mitt fucking Romney, because this is serious shit, and I think we could activate potentially millions of people in a sustained fashion. And I don't know if that's ultimately enough to stop Mitch McConnell in this power play. I don't know if it's enough to sway Susan Collins indefinitely in the lame duck session. And actually enough to like give a Supreme Court seat to Joe Biden. I don't know if it's enough to give Mitt Romney that same incentive, but I know it's possible because these people care about the institutions ostensibly. These people will react to the pressure. These people will react to the potential chaos that's going to ensue. And there are so many other elements that we could pull on that will add to that pressure. How this affects the election, and that goes both ways. How this affects the potential future re-election chances of all of these senators. Who knows? If you think Donald Trump's going to lose in November, fuck it. Who knows how the Republican base changes? Because obviously there are some pretty significant changes from 2012 to 2016. You might not feel so assured tying your horse to Donald Trump, so to speak. There's so many moving parts at play and so much opportunity to pressure that system and those moving parts. But I think more importantly, this is an opportunity to get people involved, get people engaged, and continue to build power, build networks, and radicalize liberals most importantly. And we have to fight. We we have to do that work, because frankly, the consequences of an Amy Coney Barrett replacing RBG are kind of hard for me to spell out in one episode. They are significant. We, in many ways, already have a Supreme Court that is as far right as it's been since the New Deal, and you could argue, in theory, could be as far right as it's been since the Civil War. And I think pushing Amy Coney Barrett onto the court makes that latter point, the as far right as we've been since the Civil War, brings that out of the realm of theory, and you will start seeing the results that transform our conception of contract into one more in line with the Federalist Society and the Lochner era, the era in which you have judges defending child labor laws and 7-day work weeks as actually the choice of freedom, because you have the right to contract your child's labor and you have the right to work 17 hours a day, 7 days a week, or you'll lose your job and starve. That conception of contract, the one that leads Neil Gorsuch to write dissents that say that a trucker needs to either stay and freeze to death or lose their job because that is the optimal economic outcome for business owners. I mean, that is the conception of the economy that these people are pushing. That's not to even speak to how directly, and I alluded to it earlier, how directly the judicial philosophy pushed like people like Amy Coney Barrett will fundamentally erode the work done by people like Ruth Bader Ginsburg, because particularly those far-right elements of the judiciary do not think that the 14th Amendment should function the way that Ruth Bader Ginsburg argued it should in the 70s. There's a originalist argument that says that, yeah, the 14th Amendment's Equal Protection Clause is supposed to protect people, but it was particularly passed in this post-Civil War context to protect slaves who were being integrated into society as freed people after the Civil War. And so this wasn't supposed to become what it became. It wasn't supposed to apply to women. It's not supposed to apply to transgender and non-binary people. And more importantly, the doctrine of substantive due process that flows from the 14th Amendment that isn't explicitly laid out like the Equal Protections Clause is, but has been used to justify and protect the freedoms to choose abortion and innumerable other freedoms. People like Scalia and Clarence Thomas are fundamentally skeptical of that doctrine. They don't think it should exist. And there was not serious leverage to potentially get rid of it. The doctrine that protects gender equality, that protects trans and LGBTQ marriage equality, that protects all of these changes that we're trying to see. The 14th Amendment in so many ways is pivotal, and there will be a push to repeal it and amend it and transform it in ways that will make American society all the worse. And those are on the table now. And in so many ways, these legal arguments will crop up in every area of the law, and the chance to move towards a worse society in almost every way is just live and active in a way that it hasn't been before. And that's not even to speak to the dynamic at play once you combine a 6-3 conservative Supreme Court with the packed judiciary on the lower levels that we've seen in recent years. I mean, we can see conservative judicial thought, the likes of which we just have not seen materialize into policy. And that is the world we are heading for if RBG is replaced by Donald Trump. But it is not a foregone conclusion. This is one of the most chaotic potential. As Trevor and I have discussed, this is the age of non-modal outcomes. RBG dying in this 50-day window was not a modal outcome, and it is one of the most chaotic non-modal outcomes you could choose. And that creates pressure in the system that we can take advantage of. That creates opportunity to mobilize and organize people that we can take advantage of. And we can make sure potentially that we have mobilized and activated at a level that forces people to respond. Does it force the entire Republican Party to stop their march towards fascism? Probably not. Does it force Mitt Romney to consider voting no? Does it force Susan Collins to consider sticking to her word? Does it force Chuck Grassley to consider sticking to his word? Does it force Steve Daines or Cory Gardner, who are in close Senate races, from vote? Does it make them reconsider their position? All of that is on the table. All of that is possible, and you would just be fucking stupid to say it's not. Maybe not stupid, but at least incredibly apathetic, because the entire point of this endeavor that is our shared political project is to build power to mobilize and to affect change. And if you don't think that's possible, then what the fuck are you doing? And this is a moment where the conditions are such that I think it's possible. And I've made the case that there's the pressure to be taken advantage of. I have made the case that this is a situation that will radicalize liberals that we need to take advantage of. And that's exactly what we need to do. And I think to truly do that, you need to understand how transformative RBG really was. And hopefully I provided some insight as to how transformative she was and some useful talking points. Because I think when you talk to libs going forward, making the point that RBG was sucked and that she demolished tribal sovereignty to construct pipelines, like that's true, it's valid, and we need to highlight that, especially as a movement that wants to integrate the needs of indigenous peoples. We got to keep that front and center, and we can't lose sight of that. But when you're trying to convince a liberal that the Supreme Court's not enough, that these institutions are fundamentally flawed, that you need to be more politically engaged than you are, even truly appreciating how RBG was transformative and using that to highlight how transformative someone like Amy Coney Barrett could be in the opposite, I mean, that's the work that we have to do in this moment. And it's going to be a lot of heavy lifting in the next 50 days. And there's a good chance that it ends up just like Brett Kavanaugh, and we all watch aghast as the Supreme Court nominates a literal rapist, or in this case, a literal Christian dominionist, patriarchal, fascist law professor and judge. I mean, that's where we're headed. But it doesn't have to end that way, and the only thing that ensures that outcome is the mobilization I refer to not happening. And if you're too apathetic to get involved, I can appreciate where that comes from, but I just want to assure you that this is not a moment to let that apathy win out, because this is a moment that the pressure in the system that we can take advantage of is more present than ever, and we on the left need to be prepared to take advantage of that. And so part of that is really appreciating the good and the bad of someone like RBG, and part of that's really appreciating the day-to-day machinations of the political process that's going to unfold to replace her. Part of that's appreciating just how bad her replacement really will be. And we will have more to say about each of those components going forward. We'll have more to say about RBG's legacy, the good and the bad. We'll have more to say about the political debates on who and how to replace her and when. As it stands now, I just think everyone needs to appreciate how transformative she really was, how much worse things could really be, and what we need to do to mobilize in the short term to ensure that we don't get an Amy Coney Barrett, but also in the long term to ensure that people like Ruth Bader Ginsburg have a better, more systematized conception of the law that makes up for some of her shortcomings, but also that conception of the law is tied to a movement that is also articulating that conception. So just like our RBG did in the realm of gender and gender equality, we can create a leftist system of judges that is accountable to a leftist vision. And that is possible. And I think at her best, RBG offered a glimpse of what that could look like. At her worst, she actively eroded that. And we will have more to say about both her best and her worst in the days, weeks, and months to come. We will also have a lot more on who's going to replace her and when, and what we can do to affect change and affect that process. I stand by my word. All judges are bad. We should abolish the Supreme Court. We'll continue to talk about what that looks like. But we also need to appreciate that some judges are far, far worse than others, and this is a moment that we need to make sure we get a better one than a worse one, because the worse one will have disastrous consequences. And I know that it's bleak. Things don't seem, good outcomes don't seem possible. It doesn't seem possible to affect that change and build that power. But we have to keep going, because I know things seem dark and hopeless right now, and they will probably get even darker and more hopeless in the days and months to come. But we have to keep climbing that mountain. Even if you don't believe, like Martin Luther King didn't believe, that you will get to the top, you have to keep going, because in these moments, it's the people making that climb that actually enact those changes, that actually change society. And this is one of those moments, if there ever was one. So we have to do what we can to take advantage of it. So please keep looking at the big picture, keep looking for context, keep everything in context, and keep fighting. But most importantly, look out for one another, because things are going to get worse before they get better. But I truly do believe that they can and will get better, and that comes because we, as millions of people engaged in this shared project, come together and build the power that makes it happen. That's how we ensure the judges that we receive are even better than Ruth Bader Ginsburg, and that's how we ensure that the politicians we elect create the society that we actually want to see. It doesn't come from them. It comes from a movement of people forcing them to do what we want. I'm putting them in the position to do what we want. And even though things seem hopeless right now, I truly do believe we can build the power to enact those changes, to force those issues, and to really build the society that we all want to see. And deaths of figures like RBG and the fallout that they create are significant setbacks potentially, to be sure, but they're also significant opportunities. So again, take care of one another. I know things seem hopeless, but I genuinely, truly believe that this is as much an opportunity as anything. So seize that opportunity and let's try and build a better future. I'll see you next time.